In a medical malpractice case in New York, why is it that there can be instances where the defense questions you for 7 hours, an entire day? How could that be possible? Would you like to know the answer? Come join me for a walk along the water as I share with you the answer to that question. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. You brought a lawsuit against your doctor or hospital staff claiming that they were careless and caused you significant harm and injury. And during the course of your lawsuit, the attorneys who represent the people whom you have sued will have an opportunity to question you in a process called a deposition. Lawyers also call it an examination before trial. The answers that you give in response to these questions by the defense attorneys will represent your sworn testimony, and it carries the same exact weight as if you are testifying in court at trial in front of a judge and in front of a jury. Now, the only difference is that this is happening in a somewhat informal sense, either in your attorney's conference room or on a Zoom video call. So how is it possible that it could take up to 7 hours to ask you questions about what happened and what problems you have? Well, there are a number of reasons how and why that could occur. So let me go back for a second. Many times, a junior attorney, a junior associate, is often assigned to your case at the very beginning. And now this defense attorney, this attorney who represents the doctor or hospital staff, now they have an opportunity to go ahead and ask you hundreds and hundreds, if not thousands of questions. The junior associate is often assigned to ask you questions. Why? Because there's very little risk assigned with asking you questions. It's not a high-risk scenario. Oftentimes they will come to the deposition with a stack of typewritten questions to ask you. It's almost as if they're following a script. More experienced defense attorneys don't have a script, but they have an outline that they work out of. When I see that a defense attorney comes to a deposition and has a stack of 25 typed pages, I know we're going to be there for a long time. And that's mostly because of inexperience. Another reason why it's going to take so long for an attorney to ask you questions during your pretrial deposition is that there may be a lot of medical care and treatment involved. You may have treated before any of the malpractice occurred with many different doctors over many different years. And the defense attorney will want to probe and learn about those medical treatments that you received before the incident ever occurred. That could take a great deal of time. Another reason that may account for why your deposition is taking so long is that you may not remember many details and facts. And the attorney will keep probing and asking additional questions and more follow-up questions, and you simply may not remember. Or there could be another explanation about why your deposition is taking so long. It could be that you are rambling on and on about information that you are not asked about. You may not be following your attorney's advice. When the defense lawyer asks you a simple, straightforward yes or no question, you go on and ramble for 2 or 3 minutes for each and every answer. Instead of simply answering yes or no or I don't know, you turn around, now you give long-winded explanations when none was ever asked for. In that instance, that could account for why your deposition is dragging on and on. Now, another reason is that the defense needs to know what problems you have today as a result of what occurred. They need to know what medical care and treatment you are receiving currently or from the time that the incident occurred up until today, as well as any future care and treatment you are likely to need. All of this takes time, and if you are unfamiliar or don't recall the details of many of these things, that will now prompt the defense attorney to ask you many, many follow-up questions. So don't think for a second that just because you know all the details or most of the details in your particular case, that the defense attorney is going to keep it short and sweet and get you out of there within 2 or 3 hours. That's not really what happens. Instead, the defense attorney is going to be as thorough as they possibly can. They are going to think they need to ask you every single question under the sun when in fact they really don't. But the problem is that there's no risk or harm for them to go ahead and ask questions that are not directly related and really have not a lot to do with the details of your case. The court often gives them leeway in which to go ahead and ask lots of questions because this is the discovery phase of your case. Now, remember this. The defense attorney will have copies of your medical records just like we do. The defense will have read through all of your medical records just like we will have. The defense wants to know details about those treatments. They will want to know what you complained of on each and every visit. They will want to know what the doctor did, especially their client, on each and every visit. They will want to know about conversations that you and the doctor had during each of those visits. And that's important for them to explore. So that will also account for why the deposition is going on and on. So why do I share this quick information with you? I share it with you because I want you to understand the process of what happens during a pretrial deposition. Don't think for a second that this will be a quick in and out thing where the attorney asks you a bunch of questions and then you're done for the day. No, no, no. The court gives them up to a full day, 7 hours of questioning, that they have the ability to go ahead and ask questions. More often than not, the defense attorney will take most of the day, if not the entire day, to ask you questions in a medical malpractice case. You know, I realize you're watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.